Serial number 33. Yes, at the request of the land counsel for the petitioner, a week's time as spread is granted. Yes.
Automatic. Serial number 2. Yes, Ramswamy Iyengar.
Called again, the counsel for the petitioner submits that has carried out the amendment in the memorandum of petition. For which time is granted to file the amended petition. Interim order granted earlier is extended by 4 days.
Serial number 13. Hearing on respective application. Either NG.
Yes. Agreement. Yes. Called again in the afternoon, learned. Counsel for the petitioner and learned. Counsel for respondent number 1 and learned. CG for respondent number. Learned. Counsel for respondent number 1 and 2 and learned. CG for respondent number 3. Present. Learned. Counsel for the petitioner files a memo. Learned. Counsel and HCGP for respondent submits their no objection to allow memo. Peruse the memo. Heard submission. Next page. Stated in the memo that the present respondent number 1 has instituted the proceeding under section 16(1) of the Indian Telegraph Act 1885. It with section 164 of the Indian Electricity Act 2003 before the learned district magistrate, Bangalore district at Devanahalli on 14/3/2022. The petitioner is wishing to press all his contentions made in this writ petition before the said court of learned district magistrate at Devanahalli in the aforesaid proceeding. Thus, as prayed for, the petition stands disposed of as not present, however, reserving the liberty to the petitioner to raise the contentions that have been made by him in this writ petition. He said proceeding before the learned district judge, Bangalore district at Devanahalli. However, his request for a direction to respondent number 1 and 2 to abstain from the stringing work in between the location is not considered in this petition. Yeah. I don't do that. Yes, next.
Bill number 19, B group matter. Case was met.
Please, Your Lordship, appear for the petitioner in this matter.
Real. So I'll pass over. I have got another part for the matter. I have heard it already. Yes, pass it over.
Please.
Explanation of the list is bill number 22.
Appearing on behalf of respondent number 5 in this case. my lord.
ಹೇಳಬೇಕು ನೀವು ಇದೊಂದು ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಇದೆ ಪಾಸ್ ಓವರ್ ಇದು ಆರ್ಗ್ಯುಮೆಂಟ್ಗೆ ಅದು ತಗೊಳ್ಳೋದು ಕ್ಯಾಶುವಲ್ ಆಗಿ ಇಷ್ಟಿದೆ ಅಂತ ಹೇಳೋದು ಅಷ್ಟೇ ಅಲ್ಲ. So you have completed your argument. What more you have? Is that microphone is off on?
My lords, I'm appearing for behalf of respondent number 5 in this matter.
Yes. Yes.
My lords, I would like to make a few submissions.
Petitioner is making argument.
Much obliged, my lord.
Don't interfere.
Much obliged, my lord. Much obliged.
ಅದಿದೆ ಅದು ಸರಿ ಬರ್ತದೆ. That is not the way. ಇಂಥವನ್ನೆಲ್ಲ ಮಾಡಿನೇ ಯಾವ ಸಿಸ್ಟಮ್ ಇಂಡಿಯಾದಲ್ಲಿ ಸರಿ ಕೆಲಸ ಮಾಡಲ್ಲ. ನಮ್ಮನೆ ಬಚ್ಚಲು ಸರಿ ಇಲ್ಲ ಅಂದ್ರೆ ಪಕ್ಕದ ಮನೆಗೆ ಹೋಗಿ ಸ್ನಾನ ಮಾಡ್ಕೊಂಡ್ ಬರ್ರಿ ಅಂದಂಗ ಆಗ್ತದೆ. It is your responsibility. Before the court commences its work, go there and test it, confirm that it is working properly. It's not just me. There are other parties, other side learned counsels who has to listen to his argument. Proceed, please. ಇದೀಗ ಏನ್ ಮಾಡಿದ್ರೆ ಮುಂಚೆನೆ ಮಾಡ್ಬೇಕಿತ್ತಲ್ವೇ? ಎಷ್ಟು ಹೇಳಿದ್ರು, ಓಪನ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೇಳಿದ್ರು ಕೋರ್ಟ್ ಆಫೀಸರ್ಗಳಿಗೆ ಸ್ವಲ್ಪವೂ ನಾಚಿಕೆ ಏನದಿರಲ್ಲ. ನೀವು ಹೇಳೋದ್ ಇಂಪಾಡಿ ಹೇಳ್ಕೊಂಡ್ರೆ ನಾವು ಮಾಡೋದ್ ಮಾಡ್ತೀವಿ ಅಂತಲೇ ಮಾಡ್ತೀರಿ ಎಲ್ರು. Yes, proceed please.
Has proceeded to consider the deed as mere agreement. Lordship, wherein it is not permissible. Without lordship, the ascertaining nature of the document.
ಅದು ಹೇಳಿದ್ರಲ್ರಿ ಬೆಳಗ್ಗೆ.
Yes, Lord. Quoted judgment. Number case. File number 6. After the 7 lordship in file number 7.
Before marking the document, it has to be decided whether the other party raises an objection or not, whether the document can be admissible. Only if the document can be admissible, it has to be proceeded further. It has to proceed further to mark the document as an exhibit. If it is not so, then you have to give a separate identification mark for the same. Once the document is marked as an exhibit and admitted in evidence, that cannot be questioned further. Para 6, 7, 8, 9, 10. Adar summary ashte. Munde heli.
So, judgment of Honorable Supreme Court in lordship of AR SU ASW 2015-06184 in my memo with citation in para number.
You have furnished those memo citation to other side. Yes, what it says.
Well settled that the nomenclature given to document.
ಅದನ್ನ ಇದರಲ್ಲೂ ಹೇಳಿದ್ದಾರೆ, ಅಮರನಾಥ್ ಕೇಸಲ್ಲೂ ಹೇಳಿದ್ದಾರೆ. ನಾಮೆನ್ಕ್ಲೇಚರ್ ಇಸ್ ನಾಟ್ ದಿ ಕ್ರೈಟೇರಿಯಾ. ಅದು ಬಿಟ್ಟು ಹೊಸೇನಾದ್ರೂ ಹೇಳಿದ್ರೆ ಹೇಳಿ. ಅದೇ ಪಾಯಿಂಟ್ ಆದ್ರೆ ಬೇಡ. ವೆದರ್ ಇಟ್ ಇಸ್ 1 judgment or 10 judgment, it makes no difference. Yes, that is all.
Has to be considered and has to be. So
A compulsorily registerable document with the appropriate stamp duty upon it. Yes. Yes, respondents.
Please, my lord, I prefer the respondent number 1 and 2. In my evidence, please,
Yes.
my lord, in my evidence, the
Yes.
document which is the agreement
Yes.
was marked, and he virtually he has signed that document, and it was marked, and marked with reserving his right. Kindly see, my lord, he has produced a copy of the evidence at page number 56, relevant portion at page number 56.
Yes.
56, page number 56.
Yes. He read it this
56.
morning. Yes.
Please, my lord, I will read the only relevant portion.
Yes.
I will
Please.
not read in the entirety.
Yes.
ದಾವಾಸ್ಗೆ ಸಂಬಂಧಿಸಿದ ಕುಟುಂಬ ಕರಾರನ್ನು ಹಾಜರುಪಡಿಸಿದ್ದೇನೆ. I have never said it is any other. It is the ಕುಟುಂಬ ಕರಾರು. That is the agreement. ಸದರಿ ದಾಖಲೆಯನ್ನು ವಾದಿ ತನಗೆ ಬರೆದು ಕೊಟ್ಟಿರುತ್ತಾರೆ. ಸದರಿ ದಾಖಲೆಗೆ ನಾನು ಮತ್ತು ವಾದಿ ಸಹಿ ಮಾಡಿದ್ದೇವೆ. ದಟ್ ಇಸ್ ದ ಬ್ರೆಕೆಟ್ ಅಲ್ಲಿ ದ ಫೈಂಡಿಂಗ್ ಆಫ್ ದಿ ಕೋರ್ಟ್. ಈ ದಾವೆಯ ವಾದಿಯು ಸದರಿ ದಾಖಲೆಯ ಅಸ್ತಿತ್ವ ಮತ್ತು ವಾದಿ ಸಹಿ ಮಾಡಿ ಬರೆದುಕೊಟ್ಟಿರುವ ಬಗ್ಗೆ ಅಲ್ಲಗಳೆದಿರುವ ಬಗ್ಗೆ ದಾವೆಯನ್ನು ಸಲ್ಲಿಸಿದ್ದಾಗಿ ತಮ್ಮ ಆಕ್ಷೇಪಣೆ ಇರುತ್ತದೆ ಎಂದು ಮನವಿ ಮಾಡಿರುತ್ತಾರೆ. ವಾದಿಯ ಹಕ್ಕು ಹಿತಾಸಕ್ತಿಗೆ ಚ್ಯುತಿಯಾಗದಂತೆ ವಾದ ಮಂಡಿಸುವ ಸಂದರ್ಭದಲ್ಲಿ ವಾದಿಯ ಹಕ್ಕನ್ನು ಕಾಯ್ದಿರಿಸಿ ಸದರಿ ದಾಖಲೆಯನ್ನು ನಿಶಾನೆಗೊಳಿಸಲಾಗಿರುತ್ತದೆ. And apart from that, the trial court has passed the order impounding charges of 10 times because the 100 rupees stamp paper it was written, and 10 times was fine was imposed, and that is the order was passed. And apart from that, the document itself which my learned friend has produced as per annexure F would clearly indicate that it is an agreement. Therefore, his objection, whereas he has throughout contended even in the writ petition grounds that it is a relinquishment deed. It is not a relinquishment deed. That is my humble submission. Therefore, what the order passed by the trial court does not call for interference. And apart from that, my lord, I have already parted the property and already sold, and it is in possession of the fifth respondent hearing. That is on the merits of the case. I am not making any submission on that. And apart from that, my right was accrued based on the, my lord, my father has executed a settlement deed that is in possession of the defendant number 5, because while I have sold the property, at the time I have already given the documents with him. At his evidence, he will likely to produce the same. This is my humble submission. Therefore, my humble submission is that whatever order passed by the trial court does not call for interference. This is my humble submission.
Yes. Who is the other contestant party? R5.
My lords, I am appearing for respondent number 5 in this matter, my lord.
Yes.
My lords, I'll just take 5 minutes of this honorable court's time. My lords, I would like to draw your reference to page number 62 of the petition copy in this case, my lord.
Yes.
62, my lord. Annexure F that has been produced by the petition.
Yes.
My lords, if the last paragraph may be read, whereas the immovable property and the immovable property scheduled here and below, here and after referred to scheduled property, originally belonged to the father of the properties here, and he having settled the same, second party here absolutely as per the settlement deed dated 9/3/2004, registered as document number 5544 of 2003-2004 in the office of Sub-Registrar, Mangalore City. My lords, this statement clearly itself shows that this document is not what is giving the right to the respondent to take the thing. It is merely a document confirming the said party in order to this. The right that originates regarding the partition is this registered document itself, my lord. This fact has not been put forth by the petitioner in this instant case. My lords, if I may further refer to a judgment in reference of this, my colleague has submitted the judgment wide memo dated 10/3/2022, my lord, before this honorable court.
What it says?
My lords, the judgment is of Honorable Supreme Court, wherein it says, if I may read out that particular paragraph to my lordships in the judgment of Korakunda Chalapati Rao and another is Korakunda Annapurna Sampath Kumar. It says, if we apply the test as to whether the Kararunama Patra in this case by itself affects, by itself creates, declares, limits or extinguishes right in the immovable property in question, or whether it merely refers to what appellants alleged were past transactions which have been entered into the by the parties. Then going by the words used in the document, they indicate that the words are intended to refer to the arrangement allegedly when the parties made in the past. The document by itself does not create right, declare, assign or extinguish or limit rights in the properties. My lord, the words itself clearly indicate that this is not the way in which the rights were created by the respondents. It is only a confirming letter in as to the partition deed. In fact, my lord, the petitioner, if the fact has to be pursued through, it is in page number 11 of the memo of citation, my lord, para number 35. The last line of the para number 35 is important, my lord. Thus, the Kararunama Patra may not attract section 49(1)(a) of the Registration Act, which basically says that the same may not be registered.
Yes.
Yes, my lord. If I may proceed, my lord.
Yes.
Yes, my lord. My lord, in fact, the reason why, not going much into the facts, the reason why this confirming or the normal, the very family settlement deed, it's a family settlement agreement. The family agreement was entered into is because the petitioner was not vacating at the property of the time, despite the partition deed, my lord. That will be brought before the trial court. Only in order to make sure that there is no dispute between the families, this again, the money was paid by the respondents in order to have a peaceful settlement among the family. My lord, when that being the case, this honorable court itself in plethora of judgment has held that the family agreement, which is in consequence to a particular settlement deed by which the right has itself been created, need not be registered. My lords, the trial court was very apt in saying that this, even it is not an exact deed, and it need not be registered. In lieu of the same, penalty has been imposed, which has been paid by the respondent herein. My lords, if I may also refer to the memo of citation that has been given by the petitioner himself, my lord, in page number 18 of his judgment. My lord, even if the honorable court had to consider that this present document is in the nature of relinquishment deed, your lordship, in the case of Subbaraya MN versus Vittala MN and others.
I'm not relying of any of those judgments.
Yes, my lords. The petitioner
Except
is relying
one.
on these judgments, my lord.
Okay, Amarnath.
My lord, this was the memo of citation that was submitted to me by the petitioner.
He has not pressed the same into service now in his argument.
Then much obliged, my lord. Then it is the very case of this respondent that they said, as per the virtue of the Supreme Court judgment, the document not being per se the right creating document in deed, whereas the partition deed is the one which has created the right in favor of the respondent. Then
Yes.
that being said, this document need not require to be registered under the Indian Registration Act itself, my lord.
Yes.
That is the most humble submission of me, my lord.
Yes. Thank you. Please be seated.
My lords, in fact, if I may make one more small
Yes.
submission.
Suit filed by the present petitioner as a plaintiff in OS number 411 of 2015 in the court of so. Which defendant got produced and marked that document? Defendant number
One.
the defendant number 1.
My lord, the small intervention. There's an important judgment that has to be also shown. The recent.
Not now.
Much obliged, my lord.
Defendant number 1.
Much obliged.
The cattle respondent number 1 hearing. In his evidence, got marked a document as Exhibit D3. After some deliberations, got marked a document as Exhibit D3. Bracket as Annexure F hearing. The present petitioner as a plaintiff therein objected to the marking of the said document, contending that the said document is a compulsorily registerable document. As such, it attracts duty and the registration. The court hearing both sides, the trial court, brevity trial court, the trial court of hearing both sides in its observation dated 4/11/2016. Observed that the said document is only a family agreement and that the ownership rights are not conveyed. Therefore, by imposing a penalty of ₹1,000 as 10 times of the alleged deficit duty of ₹100, I proceeded to permit marking of the said document as Exhibit D3 on the next date of hearing, that is on 15/11/2016. However, after recording in the deposition sheet that without prejudice to the rights and interest of the plaintiff, and reserving right to him to address his argument at the time of main argument in the suit, the said document came to be marked. Agreed by the said finding of the trial court dated 4/11/2016 and 15/11/2016, the plaintiff in the trial court is before this court as a petitioner. Third arguments from both sides. It is the argument of the learned counsel for the petitioner that the document in question, which is at annexure F bracket L marked as Exhibit D3, is in a sense not a mere recording of the alleged settlement in the family, nor a mere an agreement, but it is a relinquishment deed wherein the executant of the said document has relinquished their right, title, and interest in immovable property in favor of the second party in the other party in the agreement. As such, it is a compulsorily as such under section 17 of the Registration Act. It is a compulsorily registerable document. In his support, he also relied upon the judgment of Honorable Apex Court in K. Amarnath versus Srimati Puttamma, reported in ILR 1999, Karnataka 4634. Judgment of this court in ILR. This court in K. Amarnath versus Puttamma, ILR 1999, Karnataka 4634. The counsel for point number 1 and 2 in his argument submitted that the very nomenclature of the document itself go to show that it is a family agreement. As such, the concept of relinquishing of any right through the said document does not arise. He also submitted that the trial court had permitted marking of the said document as an exhibit, however, reserving liberty to the plaintiff to agitate his contention on the exhibiting of the said document at the time of the main argument. Further, it has also collected 10 times penalty. It has also collected the penalty upon the said document. The counsel for respondent number 5 submitted that a reading of the said document at annexure F go to show that it is nothing but confirming the previous settlement that has taken place in the family in the form in the present document, which is a family agreement. As such, it neither creates any right, title, or interest in favor of any one of the party afresh, nor it intends to create any such thing. However, to get the said arrangement done, a consideration was paid to the executant of the said document. Stating that to do the said document would not, in his support, he relied upon the judgment of Honorable Apex Court in Korukonda Chalapati Rao and another versus Korukonda Annapurna Sampath Kumar, reported in 2021 SCC online SC 847. In Amarnath's case bracket Supra, with respect to admissibility and marking of a document as an exhibit in a legal proceeding. It was observed that when a document is produced and it is sought to be exhibited, the court should decide whether it is admissible or not, and if it is admitted in evidence, it should be given an exhibit number after marking it as required under Order 13, Rule 4. But if it is rejected as inadmissible, an endorsement has to be made as prescribed under Order 13, Rule 6. It was further observed in the very same judgment in para 9 that when a document is produced and sought to be exhibited, the court should decide whether it is admissible or not immediately, so that the parties will know whether such a document could be relied on or not. We further observed in para 10 of the very same judgment that a duty is cast upon every judge to examine every document that is sought to be marked in evidence. The nomenclature of the document is not decisive. In Korakunda Chalapati Rao's case, bracket Supra, wherein also the marking of a document and its registerability, compulsorily registerability was in question. The Honorable Apex Court was pleased to observe in para 35 of its judgment as below. If we apply the test as to whether the Registration Act, it is keeping the above principle laid down in the above judgments in mind, the present case is required to be analyzed. Undisputedly, the suit of the plaintiff is the one for partition, separate possession, and also for rendition of accounts. One of the defense raised by the defendant number 1 in the suit is that the father of the defendant has already settled the scheduled property in his favor, and there was a settlement in the family on 14/3/2008. It is in that context and to show that the plaintiffs have got no claim over the said property, which is alleged to be the subject matter of the alleged settlement deed, the defendants come up with the document at Exhibit D3, bracket Annexure F, which is shown, which is described as unit, family agreement. between two parties. The preamble of the said document says that reads as below. Whereas the immovable property is scheduled here under the scheduled below hereafter referred to as singular comma scheduled property close the singular comma originally belonged to the father of the parties hearing bracket viz Ratnakar Rao close the bracket, and he having settled the same to the second party herein absolutely as per settlement deed dated 9/3/2004 registered as document number 5544/2003-2004 in the office of the sub-registrar Mangalore city and colon ... The parties herein have executed this family agreement. A recital as above would go to show as to what necessitated the parties to enter so-called family agreement dated 14/3/2008 as per Annexure F bracket Exhibit D3. However, the active portion of the alleged family agreement, which is the crux of the alleged family agreement, is very material. The said crux of the matter, after reciting about passing off of a consideration of a sum of rupees 8,50,000 from the second party to the first party, the receipt of which the first party has acknowledged in the very same document, bracket and family agreement, further recites at para 3, 4, and 5 as below. 3. The first party declares that the above consideration. Para 4, the first party also declares that he is bound by the above settlement. 5. The first party declares that in the event of his claiming, at the end, the schedule of the property is also given in the document, given in the document. At the end of the document, the schedule of the property is also mentioned. A careful reading of the above, more particularly para 3 of 3, which is extracted above, clearly go to show that apart from the first party declaring that the amount received by him under the said family agreement is the full and final settlement of his claim, also has declared that he, bracket first party, shall have no claim, right, title, and interest whatsoever in the scheduled property. Further, he has also declared that he is bound by the settlement deed, and he further declared that in the event of his claiming the right in the scheduled property or any of the assets of the assets of the father or family, or to file any legal proceeding against the second party, the said second party is entitled to recover the said consideration amount of rupees 8,50,000. Thus, even though the said document in its nomenclature is called as a family agreement, but actually and in fact, the first party under the agreement, in return for the consideration received by him, which is a sum of rupees 8,50,000, has acknowledged and has declared that he shall not have any claim, right, and interest over the scheduled property. Thus, he has given away his right, title, and interest over the scheduled property in return for a valuable consideration in favor of the second party to the agreement. Section 17 of the Registration Act 1908, which speaks about the documents that are compulsorily registerable at 17(1)(b), mentions that non-testamentary instruments which purport or operate to create, declare underline ಮಾಡಿ, assign, limit, or extinguish underline ಮಾಡಿ, dot are compulsorily registerable. In the instant case, a reading of Annexure F bracket Exhibit D3 in its entirety gives the meaning that apart from the parties to the agreement acknowledging the alleged settlement deed dated 9/3/2004, have through the present agreement at Annexure F bracket Exhibit D3 have declared the right of the second party to the agreement and it is declared that the first party shall not have any claim, right, title, and interest over the scheduled property, and thus it has resulted in extinguishing of the rights of the first party with respect to scheduled property mentioned therein, and the declaration of the rights of the second party for a valuable consideration. Therefore, it is a compulsorily registerable document with appropriate stamp duty, etc. However, the trial court, without looking into these aspects, merely by going into the nomenclature of the said document, has treated this as a mere family arrangement. It is needless to say that mere reserving a right to the plaintiff to rake up the point at a later stage would not by itself entitle for exhibiting a disputed document in evidence and marking it as an exhibit and getting it admitted. As observed in Amarnath's case bracket supra, if any such disputes are arisen, it's the duty of the court which records the evidence to then and there itself to decide, then and there itself to hear on the objection and to decide it regarding marking of the document and its admissibility. Therefore, merely because the trial court has observed that the plaintiff therein who objected to the marking of the said document can agitate his objection at a later stage during the at a later stage, which is during the arguments on the main suit, itself would not entitle the party who produces the said document to get it marked as an exhibit and get it admitted in the evidence. As such, the finding of the trial court dated 4/11/2016 and 15/11/2016, which are included in this writ petition, since it does not sustain, are required to be quashed. Accordingly, the writ petition is allowed and the impugned orders dated 4/11/2016 and 15/11/2016, passed in OS number 411 of 2015, on the file of the Principal Senior Civil Judge and CJM, Mangaluru, Dakshina Kannada, bracket annexion A, stands quashed. Even pass over the law.
We will pass our matters to number 19. Dear Cosmat.
Please, Your Lordship. Appear for the petitioner in this matter.
Yes. Thank you. One more. Yes.
Lord, suit for partition and separate possession filed by respondent number 1. Suit
One
came
minute.
to be decreed. Please.
1 minute. Yes, please.
Please, Your Lordship. Respondent number 1 herein filed a suit for partition and separate possession. Suit came to be decreed. After that, he filed the final decree proceedings. In the meantime, respondent number 2 herein filed an appeal challenging the judgment and decree. That appeal came to be partly allowed, altering the shares of the petitioner as well as the respondents from 1/4, which was allotted in the OS, to 5/16 each, and respondent number 3 herein gets 1/16 share. Then the appeal court also gave the liberty to respondent number 2 herein to file an application before the FDP court, where he can seek to protect and preserve his right over the property, which is under cultivation from many years. So the respondent number 2 herein files an application in the FDP court seeking under section 151 of CPC, seeking to preserve and protect his possession over the and allot that property to his share. For that application, respondent number 1 herein has filed objections. And respondent number 2
Who has filed that IA? Who has
IA
filed that IA for protection?
Respondent number 2 in the writ petition, Your Lordship.
Respondent number 2.
2.
Yes.
That is at annexure D. Aditya, respondent number 1 herein files his objection. Petitioner and respondent number 3 did not file. The court comes to a conclusion that since only respondent number 1 is the petitioner in the respondent number 1 herein is objecting to the application, let the right of respondent number 2 be preserved so far as that property where he is already cultivating is concerned, and the remaining property situated at this Hasan Taluk may be granted to the respondent number 1 herein anta. Andre nanige ottu petitioner enu share kottilla Hasanalli land is somewhere around 17.5 acres. Out of that, the respondent number 2 herein gets 12.5 acres, and the remaining 5 acres go to respondent number 1 only because he objected for the application. Nan object madilla annod onde reason. Adu bittu bere reason enu FDP court. Please, Your Lordship.
Ultimately, the parties are brothers and sisters, right?
Please, Your Lordship.
1 sister and 3.
Illa, mother, 3 brothers.
Mother, 3 brothers. Why don't you amicably settle the matter?
That was also tried, Your Lordship.
Now, once again, say it can be done. That might have happened there.
Illa,
Because the mediators say the parties might not have been inclined. Everyone talks, and material say some conclusion might not have come. Ultimately, take it from me, if this goes for another 15 years, none of you could be able to enjoy the property. At least for another 15 years, this will continue. And there, say the vested interest or the right in the undivided properties also, some of the parties will be constrained to sell in the meantime. Some purchaser, some third party, some purchaser, may with risk involved therein, he will say financially assist some of the party herein and creates his right and interest in the property. The old soul mother doesn't have a peaceful death in the course of the time. These are all sure of happening, provided if you continue this audacity, all the three. Mediator battery, forget about mediator, forget about Lok Adalat, forget about conciliator. ನೀವೇ 3 ಜನ ವಕೀಲರು ಕೂತ್ಕೊಳ್ಳಿ, ಪಾರ್ಟಿಗಳನ್ನು ಕೂರಿಸ್ಕೊಳ್ಳಿ, ವಕೀಲರು ಮಾತಾಡಬೇಡಿ, ವಕೀಲರು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಬೇಡಿ. ನೀವು ಕೇವಲ ನಿಮ್ಮ ಹಿಂದೆ ವಕೀಲರು ಇದ್ದಾರೆ ಅಲ್ಲಿಕ್ಕೆ ಮಾತ್ರ, ಉಳಿದಂತೆ ಅವರೇ ಮಾತಾಡ್ಕೊಳ್ಳಿ.
In fact, as your lordship said, parties audacity and the law, that is 100%. I'm sorry.
ಈಗ ಅಕಾರ್ಡಿಂಗ್ ಟು RA ಈಗ ಟೋಟಲಿ ಎಷ್ಟು ಪ್ರಾಪರ್ಟೀಸ್ ಇದೆ, ಎಷ್ಟು ಐಟಮ್ಸ್ ಇದೆ? ಎರಡೇ ಐಟಮ್ ಪ್ರಾಪರ್ಟಿ. ನಾಳೆಯಿಂದ ಒಂದು ಬೋರ್ಡ್ ಬರ್ಸಿ ಹಾಕ್ರಿ. ಸುಭಾಷಿತ, ಜೀವನವನ್ನು ನೆಮ್ಮದಿಯಾಗಿ ಕಳೆಯಬೇಕಾದ್ರೆ ಆಸ್ತಿಪಾಸ್ತಿಗಳನ್ನು ಸಂಪಾದಿಸಬೇಡಿ. ಸಂಪಾದಿಸಿದ್ರು ಕೂಡ ಸಾಯುವ ಮುಂಚೆ ತಪ್ಪದೆ ಅದನ್ನು 3ರವರೆಗೆ ದಾನ ಮಾಡಿ ಅದನ್ನು ಅವರು ಉಪಯೋಗಿಸುವುದನ್ನು ಖಾತ್ರಿಪಡಿಸಿಕೊಂಡ ನಂತರವಷ್ಟೇ ಸಾಯಿರಿ. ಇದರಲ್ಲಿ ಯಾಕೆ ಬೇಕು? ಪ್ರತಿ ದಿವಸ ಬೆಳಗ್ಗೆ ಕೂತಲಿಂದ ಸಾಯಂಕಾಲ ಹೋಗಲಿವರೆಗೂ ಅಣ್ಣ ತಂಗಿ ಹೊಡೆದಾಟ, ಅಕ್ಕ ತಮ್ಮನ ಹೊಡೆದಾಟ, ತಾಯಿ ಮಕ್ಕಳು ಹೊಡೆದಾಟ, ಆಸ್ತಿ ಆಸ್ತಿ ಆಸ್ತಿ. ಇವ್ರ ಕಾರ್ಗಳು ನೋಡಿದ್ರೆ ಚೇಂಜ್ ಆಗ್ತಿದೆ. ಆಲ್ಟೋ ಇಂದ ಸ್ಕೋಡಾ, ಸ್ಕೋಡಾ ಇಂದ BMW. ಈಗ ಇಮ್ಮೋಬಲ್ ಪ್ರಾಪರ್ಟಿ ಹಾಸನ ಮತ್ತು KR ಪೇಟೆ. ಈಗ 4 ಜನ ಅಣ್ಣ ತಮ್ಮಂದ್ರಿಗೂ ಒಬ್ರು ತಾಯಿ ಇದ್ದಾರೆ ಅಲ್ವೇ? ಸುಬ್ಬಮ್ಮ ಡೈಡಾ? ಮತ್ತೆ ರೆಕಾರ್ಡ್ ಮೇಲೆ ತಂದೆ ಇಲ್ಲ ಬೇರೆ ಯಾರನ್ನು? ಆ ರೀತಿ ಆರ್ಡರ್ ಆಗಿದೆಯಾ? ಅದರ್ ಪಿಟಿಷನರ್ಸ್ ಆಫ್ ದಿ ಲೀಗಲ್ ರೆಪ್ರೆಸೆಂಟೇಟಿವ್ಸ್ ಅಂತ ಆರ್ಡರ್ ಆಗಿದೆಯಾ? ಹಾಗಾದ್ರೆ ನಾಳೆ ಟೆಕ್ನಿಕಲಿ ಮತ್ತೆ ಪ್ರಾಬ್ಲಮ್ ಆಗ್ತದೆ ನಿಮಗೆ. ಯಾರೋ ಒಬ್ರಿಗೆ ಏನಾದ್ರು ರಿಟ್ ಪಿಟಿಷನ್ ಆರ್ಡರ್ ಹಿಡಿಸ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಅವರಿದ್ದವ್ರಿಗೆ ಟೆಕ್ನಿಕಲ್ ಇಶ್ಯೂ ತಗೊಂಡ್ಬಿಡ್ತಾರೆ. ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಯು ಕೆನಾಟ್ ಪ್ರೊಸೀಡ್ ಇನ್ ದ ಮ್ಯಾಟರ್. ಯಾರೇ ಆಗ್ಲಿ ಎಲ್ರಿಗೂ ತಾಯಿನೇ ತಾನೇ. ಪಿಟಿಷನರ್ ಹ್ಯಾಸ್ ಟು ಸೇ, ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಶುಡ್ ನಾಟ್ ಸೇ ಇಲ್ಲ. ಈ ಆಟಿಟ್ಯೂಡ್ ಹೋಗ್ಬೇಕು. ಇಂಥ ಫ್ಯಾಮಿಲಿ ಮ್ಯಾಟರ್ಗಳಲ್ಲಿ ವಕೀಲರು ಸ್ವಲ್ಪ ದೂರ ನಿಂತರೆ ಅವ್ರು ಸೆಟ್ಲ್ ಮಾಡ್ಕೊಳ್ತಾರೆ. ನೀವು ಹೋಗಿ ಅದ್ ಯಾಕಾಗಲ್ಲ ನಾ ಕೊಡಿಸ್ತೀನಿ ಬಾ ಅಂತ ಹೇಳಿದಾಗ ಎಲ್ಲವೂ ಶುರುವಾಗ್ತದೆ. ಒಂದು ಲೈಟರ್ ಸೈಡ್ ಐ ಆಮ್ ಟೆಲ್ಲಿಂಗ್. So that Hasana property is ancestral property. ಆಕೆಯ ಷೇರು ಇರ್ತದೆ ಅಲ್ವೇ ಹಾಸನ ಪ್ರಾಪರ್ಟಿಯಲ್ಲಿ? ಆಕೆಯ ಷೇರು ಶಿವಲಿಂಗೇ ಗೌಡ್ನಿಗೆ ಬರಲ್ವೇ? The share going to the mother would not be her absolute property. Then is it not the adopted son also gets a share in that? ಅದಕ್ಕೆ ಇನ್ನೊಂದು ರೌಂಡ್ ಲಿಟಿಗೇಷನ್ ಇದೆ ನಿಮ್ಮದು. ಡೆಫಿನೆಟ್ಲಿ ನಾನು ಹೇಳ್ತಿಲ್ವೇ, ನೀವುಗಳು ನಿಮ್ಮ ಸೆಲ್ ಫೋನ್ಗಳನ್ನ ಹಳೇದು ನೋಕಿಯಾ 1110 ಆ ಮಾಡೆಲ್ಲ ಇಟ್ಕೊಳ್ತೇವೆ, ಹೊಸದಕ್ಕೆ ಹೋಗಲ್ಲ. ಐಫೋನ್ ಎಲ್ಲ ನಮ್ ಇದ್ರಲ್ಲೇ ಇಲ್ಲ ಅಂತ ಆಲೋಚನೆ ಮಾಡಿ. ನಾವು ಹಳೆ ವಕೀಲರು ಬರ್ತಿರಂಗೆ BMTC ಬಸ್ ನಲ್ಲೇ ಬರ್ತೇವೆ ನಾವು. ನಮಗೆ ಲೇಟೆಸ್ಟ್ ಬ್ರ್ಯಾಂಡ್ ಕಾರ್ ಬೇಡ ಅಂತ ಯೋಚನೆ ಮಾಡಿ. ಪಾರ್ಟಿಷನ್ ಸೂಟ್ಗಳೆಲ್ಲವೂ ಬೇಗ ಸೆಟ್ಲ್ ಆಗ್ತವೆ. ಏನಿಲ್ಲ, ತಮಾಷೆಗೆ ಹೇಳಿದ್ದನ್ನ ಲೆಕ್ಕಕ್ಕೆ ತಗೊಳ್ಬೇಡಿ. ಇದರಲ್ಲಿ ಯಾರು ಮಾತಾಡೋರಿದ್ದಾರೆ, ಯಾರ ಪ್ರಕಾರ ಇದ್ದಾರೆ, ನೀವು ನಿಮ್ಮ ಕಕ್ಷಿದಾರರಿಗೆ ಹೇಳಿ. ನಿಮ್ಮ ಕಕ್ಷಿದಾರರಿಗೆ ಹೇಳಿ. ಮ್ಯಾಟ್ರ್ ಬಂತಪ್ಪ, ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ವಿ, ಕಂಡಾಪಟ್ಟೆ ಬೆಳಗಿಂದ ಸಾಯಂಕಾಲದವರೆಗೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ವಿ. ಸಾಹೇಬ್ರು 4 ಸಲ ನೀರು ಕುಡಿದ್ರು. ಅಷ್ಟು ಜಬರ್ದಸ್ತಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ವಿ. ಆದ್ರೂ ಉಳಿದವ್ರದ್ದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಎಲ್ಲ ಕೇಳಿದ್ವಿ. First ಇದನ್ನ ಮಾಡಿ, you bring the legal representative of the deceased Subamma on record, or in a manner known to law, get recognition that the other parties are the legal representatives of which is Subhamma. A mere memo won't do. If any order is already done, then no point of doing any fresh thing. If there is no such order, that has to be done. Adanna Madi, including the petitioner, any of has to do that. And then prepare a list of the total number of properties in which the disputing parties are entitled. Disputing properties are entitled. Whether it is 5/6 share or 1/16 share or whatever it may be, as per the REA judgment. So ಆ ರೀತಿ ಮಾಡಿದ್ರೆ ಅವರಿಗೆ KR-ಪೇಟೆ ಪ್ರಾಪರ್ಟಿಯಲ್ಲಿ ಎಷ್ಟು ಬರ್ತದೆ, ಹಾಸನ ಪ್ರಾಪರ್ಟಿಯಲ್ಲಿ ಎಷ್ಟು ಬರ್ತದೆ, ಟೆಂಟೇಟಿವ್ಲಿ ಈಚ್ ಒನ್ ಪ್ಯೂರ್ಲಿ ಸ್ಟ್ರಿಕ್ಟ್ಲಿ ಗೋಯಿಂಗ್ ಬೈ ದಿ ಡಿಕ್ರಿಟಲ್ ಟರ್ಮ್ಸ್, ಡಿವೈಡ್ ದಿ ಪ್ರಾಪರ್ಟಿ ಬೈ 5/16 1/16 ಏನ್ ಹೇಳಿದ್ದಾರೆ ಆ ಪ್ರಕಾರ ಮಾಡಿದ್ರೆ ಯಾರ್ಯಾರಿಗೆ ಕಂಟೆಸ್ಟಿಂಗ್ ಪಾರ್ಟಿಗಳು ಎಲ್ರಿಗೂ ಯಾರ್ಯಾರಿಗೆ ಎಷ್ಟೆಷ್ಟು ಬರ್ತದೆ ರಫ್ ಸ್ಕೆಚ್, ನಾಟ್ ಫೈನಲ್, ಅದೊಂದು ಚಾರ್ಟ್, ರಫ್ ಚಾರ್ಟ್ ಮಾಡಿ. ಈಗ ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 2 ಯಾರು ಅದನ್ನ ನರಿಹಳ್ಳದ ಪ್ರಾಪರ್ಟಿ ಅವರಿಗೆ ರಿಟರ್ನ್ ಆಗ್ಬೇಕಂತ ಹೇಳಿದ್ದಾರೆ, ಅದು ಎಷ್ಟು ಎಕ್ಸ್ಟೆಂಟ್ ಇದೆ, ಅವರಿಗೆ ಅದು ರಿಟೈನ್ ಆದ್ರೆ ಉಳಿದವರಿಗೆ ಅವ್ರು ಏನಾದ್ರು ಎಕ್ಸ್ಟ್ರಾ ಕೊಡ್ಲಿಕ್ಕೆ ಯಾರಾದ್ರೂ ತಯಾರಿದ್ದಾರಾ? ಪ್ಲೀಸ್ ಪ್ಲೀಸ್. ಇಲ್ಲದೆ ಹೋದ್ರೆ ಒಂದು ಫೈನ್ ಡೇ in order may come for the sale of the property. That is 100% sure. Even though the very same person also retain the property, third party interest create agade hodru kuda, there is all the possibility of the court directing the sale of a disputed property and distribute the sale proceeds among all the sharers. ಅವಾಗ ನಿಮಗೆ ನಿಮಗೂ ಇಲ್ಲ ಇನ್ನೊಬ್ಬರಿಗೂ ಇಲ್ಲ ಅಂತ ಮೂರನೇವರೆಗೆ ಹೋಗ್ತದೆ. ಒಂದು ಸರ್ತಿ ಸೇಲ್ ಅನ್ನ ಇಂಟೆನ್ಷನ್ ಬಂದ್ರೆ that is the main entrance for every third party to enter the arena. ಬೇಕಾಗ್ಲಿ ಬೇಡ ಆಗ್ಲಿ ದಿ ಅನ್ವಾರಂಟೆಡ್ ಬಿಡ್ಗಳು ಶುರುವಾಗುತ್ತೆ, ಕಾಂಪಿಟೇಷನ್ ಶುರುವಾಗುತ್ತೆ. ಹಾಸನ ಪ್ರಾಪರ್ಟಿ ಅಂತೂ ಬಹುಶಃ ಅದನ್ನ ಯಾರು ಬಿಟ್ಕೊಡ್ಲಿಕ್ಕೆ ತಯಾರಿರಲ್ಲ, ಆ ರೀತಿ ಹೋಗ್ತದೆ. ಅದ್ರ ಬದಲು ಇರ್ತಕ್ಕಂತಹ 4 ಮಂದಿ ಅಣ್ತಮ್ಮಂದ್ರು ಅವರು ಸ್ವಲ್ಪ ತಮ್ಮ ವಿವೇಚನೆಯನ್ನು ಸರಿಯಾಗಿ ಬಳಸಿದ ಪಕ್ಷದಲ್ಲಿ ಅವರವರ ಬೇಕು ಬೇಡಗಳನ್ನು ಗಮನಿಸಿದ ಪಕ್ಷದಲ್ಲಿ ಬಹಳ ಪೀಸ್ಫುಲ್ ಆಗಿ ಸೆಟ್ಲ್ ಆಗ್ತದೆ. ಈ ಪ್ರಕಾರ ನೀವು ನಿಮ್ಮ ಕಕ್ಷಿದಾರರನ್ನ ಮೆಂಟಲಿ ಪ್ರಿಪೇರ್ ಮಾಡಿ. ಕರೆಸಲಿಕ್ಕೆ ಮುಂಚೆ ಇಲ್ಲಪ್ಪ ಆರ್ಗ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ ಆಗಿದೆ, ನೀವು ಬರಬೇಕು ಕೋರ್ಟಿಗೆ ಇಂಥ ತಾರೀಕು ಬರ್ರಿ ಅಷ್ಟೇ ಹೇಳಿ ನಿಲ್ಲಿಸಬೇಡಿ. ಅಷ್ಟೇ ಹೇಳಿ ನಿಲ್ಲಿಸಿದ್ರೆ ಸೆಟ್ಲ್ ಆಗಲ್ಲ. ನೀವು 3 ಮಂದಿ ವಕೀಲರು ನಿಮ್ಮ ಕಕ್ಷಿದಾರರುಗಳಿಗೆ ಜಬರ್ದಸ್ತಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರು ಮಾರಾಯ, ಅದಕ್ಕೆ ಹೊಸ ಕಾನೂನು ಇದೆ, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಡೈರೆಕ್ಷನ್ ಇದೆ. ಅಣ್ತಮ್ಮಂದ್ರ ನಡುವೆ ಆಸ್ತಿನಲ್ಲಿ ಹಂಚಿಕೆ ಕುರಿತಂತೆ ಬಹಳ ತಗಾದೆಗಳು ತರಲೆಗಳು ಬಂತು. ಇಮಿಡಿಯೇಟ್ ರಾಜಿಗೂ ತಯಾರಿಲ್ಲ, ಅಥವಾ ಯಾರಿಗೋ ಒಬ್ರಿಗೊಂದು ಪ್ರಾಪರ್ಟಿ ಉಳಿದಿರೋದ್ರಲ್ಲಿ ಜಾಸ್ತಿ ಭಾಗ ಅದಕ್ಕೂ ತಯಾರಿಲ್ಲ ಅಂತಾದ್ರೆ ಕೋರ್ಟ್ ಎಲ್ಲವನ್ನೂ ಮಾರಾಟಕ್ಕೆ ಹಚ್ಚಿ ಬಿಡುತ್ತೆ. ಒಂದ್ಸಲ ಕೋರ್ಟ್ ಎಲ್ಲ ಆಸ್ತಿನೂ ಮಾರಾಟ ಮಾಡ್ರಿ, ಅಥವಾ ಯಾವ್ದು ಇಂಪಾರ್ಟೆಂಟ್ ಇದೆ ಇದರಲ್ಲಿ ನರಿಹಳ್ಳದ ಪ್ರಾಪರ್ಟಿ ಅದನ್ನ ಮಾರಾಟ ಮಾಡ್ರಿ ಅಂತ ಏನಾರು ಹೇಳಿಬಿಡ್ತು ಅಂತ ಆದ್ರೆ ಅದನ್ನ ಆಮೇಲೆ ನಿಮ್ ಕೈಗೆ ಸಿಗಲ್ಲ, ಅವಾಗ ಇರೋದು ಇನ್ನೂ ಪ್ರಾಬ್ಲಮ್ ಆಗುತ್ತೆ ನಿಮ್ಗೆ ಅಂತ ಹೇಳಿದ್ರೆ ಮೆಂಟಲಿ ಅವರು ಇಲ್ಲ ಇದನ್ನ ಪ್ರಾಪರ್ಟಿ 3ನವರಿಗೆ ಹೋಗ್ಲಿಕ್ಕೆ ಅವಕಾಶ ಮಾಡಿಕೊಡಬಾರ್ದು, ನಮ್ಮ ಕುಟುಂಬದಲ್ಲೇ ಇದು ಆಸ್ತಿ ಇರಬೇಕು ಅನ್ನುವ ಒಂದು ಮಾನಸಿಕ ಸಿದ್ಧತೆಯೊಂದಿಗೆ ಬರ್ತಾರೆ. ಅಷ್ಟು ಅವ್ರನ್ನ ನಾವು ಯುನೈಟ್ ಆಗಿ ಇಟ್ಕೊಂಡ್ಬಿಟ್ರೆ, ಎಸ್ ದಿಸ್ ಇಸ್ ಅವರ್ ಫ್ಯಾಮಿಲಿ ಪ್ರಾಪರ್ಟಿ, ಲೆಟ್ ಇಟ್ ಬಿ ಅಮಾಂಗ್ ವಿ ಬ್ರದರ್ಸ್ ಓನ್ಲಿ ಅಂತ ಹೇಳಿ ಇಟ್ಕೊಂಡು ಬಂದ್ಬಿಟ್ರೆ ಮುಂದಿನ ಸ್ವಲ್ಪ ಸರಳ ಆಗುತ್ತೆ. ಆ ಪ್ರಕಾರ ಮೆಂಟಲಿ ಪ್ರಿಪೇರ್ ಮಾಡಿ ಬನ್ನಿ. ನಿನ್ ಕೇಸ್ ವೀಕ್ ಇದೆ, ಅವ್ರ ಕೇಸ್ ಸ್ಟ್ರಾಂಗ್ ಇದೆ, ಅಥವಾ ಅವ್ರ ಕೇಸ್ ವೀಕ್ ಇದೆ, ನಿನ್ ಕೇಸ್ ಸ್ಟ್ರಾಂಗ್ ಇದೆ, ಏನು ಹೇಳೋದಲ್ಲ. ದಿ ಆಕ್ಚುಯಲ್ ಪೊಸಿಷನ್ ಆಫ್ ದಿ ಲಾ, if the property is undivisible, it is found that it is not feasible to divide the property. If a sale is ordered, then what these 4 people would do? ಅಲ್ಲವೇ? ಅದನ್ನ ಹೇಳಿ ಬರ್ತಾರೆ ಅವಾಗ ದಾರಿ ಮಾಡು. ಈಗ ಬೇಡ, ನೀವು ಅವ್ರನ್ನ ಕರೆಸಿ ಫಸ್ಟ್ ಅವ್ರು ಲೀಗಲ್ ರೆಪ್ರೆಸೆಂಟೇಟಿವ್ಸ್ ರೆಕಾರ್ಡ್ಗೆ ತನ್ನಿ. ಆಮೇಲೆ ಮಾಡಿ. ಈಗ ಯು ಆರ್ ಶೂರ್ ದಟ್ ಸೇ ದಿ ಡೆತ್ ಆಫ್ ಸುಬ್ಬಮ್ಮ ಹ್ಯಾಸ್ ನಾಟ್ ಬೀನ್ ಬ್ರಾಟ್ ಆನ್ ರೆಕಾರ್ಡ್ ಹಿಯರ್. ಏನಾದ್ರು ತಂದಿದ್ದೀರೇನ್ರಿ ಪಿಟಿಷನರ್?
No, my lord, no, my lord. ಗೊತ್ತಿಲ್ಲ. This is the first time I'm actually listening that she is no more.
ಯಾವಾಗ ಹೋದ್ರು ಇವರು? Learned counsel from both sides are present. Learned counsel for respondent submits that as per the information given to them, the respondent number 3, Srimati Subbamma, who Subbamma is reported to be dead. With this, counsels pray for some more time to do needful in the matter. They further submit that though this matter has once written from the mediation as not settled, however, they are hopeful of the parties who, being the brothers inter se, settling the matter amicably. List the matter after 2 weeks. After ಎಲ್ಲರನ್ನ ತನ್ನಿ ಕೆಚ್ಚನ್ ಮಾಡಿ ಮೆಂಟಲ್ ಅವ್ರನ್ನ ಮಾಡಿ ಕರ್ಸುವ. It is their property, let them enjoy. ನೋಡು, hope for best.
Yes, sir.
24.
But I appear for the petitioner in this case, my lord. My lord, I appear for the petitioner. What
Yes,
has
please.
Please, my lord. What has happened is that on 15/3, the lordship had granted 2 weeks time to file an application to bring the LRs of disease R4 and 13, my lord. Not 2 weeks time was granted. However, I filed the application today morning, my lord.
Learned counsel for the petitioner appearing through video conference submits that he has filed legal representative's application. He has filed necessary applications to bring the legal representatives of deceased respondent number 4 and 13 on record, in the registry today. ನಿಮಗೆ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರೇನ್ರಿ? Learned counsel for ಯಾರಿಗೆ ತಾವು? Respondent number 1, who is physically present, submits that copy of the said application as not furnished to her. Counsel for the petitioner undertakes to furnish her a copy within a week from today. Next time, if LR applications are filed in the registry to put up the same. Yes, let the application come.
25. V. Vinod Reddy.
Appear for petitioner in this case, my lordship.
Yes.
Prays for a week's time, my lordship. My regular counsel is not keeping well, my lordship. Kindly have it on Monday, my lordship.
Then appear for respondents at the request of the learned junior counsel for the petitioner. A week's time as spread is granted. Yes.
Cell number 26 agent. Cell number 27 group AKR.
You are not pressing the writ. You said they have taken the instruction. I thought that say not pressing the writ. Yes. So your detached claims came back again. Hunting you. Good. One minute. Annexure B. You have challenged the alleged compromise decree. You are a party to the compromise decree. You are contending that a fraud has been played upon you.
In the facts, if you go through the annexure C, my lords,
You are alleging a fraud
made by the
made by other party to the suit, which has ultimately resulted into a compromise petition. Is it not required of you to seek further relief of setting aside that compromise decree or any variation in the very same court which has recorded the compromise?
what is right in the game, my lord? Why I prefer to fight this, my lords? She's an elder sister, my lords. Brother, she has actually taken care of her brother like anything. What happened before the trial court? They have made the all the compromise petition. She resides in Shumaga, and these all three made him come to the sea, and without knowing that they will pay this much of amount they took. And
ಅವರು ನಿಮಗೆ ಮೋಸ ಮಾಡಿದವರೇನ
ಖಂಡಿತ ಸ್ವಾಮಿ.
ನೋಡಿ
ಆ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸ್ವಾಮಿ ಏನಾಗುತ್ತೆ, ಅವರು ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಆಫೀಸರ್ ಹೋಗ್ತಾರೆ, ಆಫ್ಟರ್ ರಿಜಿಸ್ಟ್ರೇಷನ್ actually what they have to out of the record, my lords, has beaten up her husband. ಹೊಡೆದ್ಬಿಟ್ಟು ಚೆನ್ನಾಗಿ ಗಾಯ ಮಾಡಿ ಗಲಾಟೆ ಆಗುತ್ತೆ ಸರ್. ಬಟ್ there is no FIR, nothing, that I out of the record. And in that background they approached me for the legal suggestion when I was working in legal aid clinic. I thought if they come before the High Court, in front of the High Court, they cannot lie. That's that intention.
ನಮಗಿಂತ ಜಾಸ್ತಿ ಶಕ್ತಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಜಡ್ಜ್ಗಳಿಗೆ ಇರುತ್ತ್ರಿ. ನಾವೆಲ್ಲ ಸರ್ವಿಸ್ ಮಾಡಿ ರಿಟೈರ್ಮೆಂಟ್ ಆಗ್ಬೇಕಾದ್ರೆ ನಿಶಕ್ತಿ ಹೊಂದಿ ಇಲ್ಲಿ ಬಂದಿರ್ತೀವಿ. ಅವರೆಲ್ಲರೂ ಯಂಗ್ ಅಂಡ್ ಎನರ್ಜೆಟಿಕ್ ಇರ್ತಾರೆ. ದೇ ಕ್ಯಾನ್ ಫೈಟ್ ಬೆಟರ್.
Having the remove the 26 to 27 with jurisdiction. Because of in that bad.
Point is very simple. Your main ground for seeking quashing of the compromise decree is on alleged fraud. It is not any other question of law that is involved or any other legal issues that are involved. The alleged fraud being purely a alleged question of fact which has to be established before the court which has passed the compromise decree. Any petition seeking variation or setting aside of the compromise decree is required to be filed with the same court. So instead of this court making such an observation and disposing of the matter, why don't to withdraw the writ petition with the liberty to file an appropriate petition before the competent court? ಏನ್ ಸೈಟೇಷನ್ ಅದು? 2 ಅಲ್ಲ ಒಂದು ನಿಮಿಷ. ಯಾವ ವರ್ಷದ್ದು ಯಾರು ಮಾಡಿದ್ದದು ಏನ್ ಪಾಯಿಂಟ್ ಮೇಲೆ ಇದೆ? ವೆದರ್ ದಟ್ ಪಾಯಿಂಟ್ ಈಸ್ ಕ್ಯಾನ್ ಎ ಕಾಂಪ್ರಮೈಸ್ ಡಿಕ್ರಿ ಬಿ ಚಾಲೆಂಜ್ಡ್ ಇನ್ ಎ ರಿಟ್ ಪಿಟಿಷನ್ ಅನ್ನೋ ಕ್ವಶನ್ ಮೇಲೆ ಇದೆಯೇ? ನಾಟ್ ಎ ಮಿಯರ್ ಕ್ವಶನ್ ಆಫ್ ಫ್ರಾಡ್. A simple alleged fraud, a simple misrepresentation under certain circumstances, the writ jurisdiction can entertain. ಅದಕ್ಕೆ ನೀವು 3 ತಂದ್ರೆ ನಾನು 13 ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡಬಲ್ಲೆ. ಇಲ್ಲಿ ಪಾಯಿಂಟ್ in a compromise decree, when the allegation is that the very compromise decree itself was entered into by some fraud played upon you. Allegation of a fraud in some act which has resulted in some order is different. The very fraud is alleged in entering into a compromise is different. ILR ಇದೆಯೇನ್ರಿ ಇಲ್ಲಿ? ILR 2015 Karnataka 4024 ತೆಗಿರಿ. ಯಾವ ವರ್ಷ ಅದು? ನೋಡಿ ರೆಡ್ ನೋಟ್ ಅದ್ರಲ್ಲಿ ನಾನು ಪೆನ್ಸಿಲ್ ಅಲ್ಲಿ ಮಾರ್ಕ್ ಮಾಡಿರೋ ಪೋರ್ಷನ್ ನೋಡಿ. ಡಿವಿಷನ್ ಬೆಂಚ್ ಜಜ್ಮೆಂಟ್. How you overcome that? The only remedy available. Either this principle or your principle. That principle. Then how can you maintain this? ಕೊಡಬಹುದು, ಅದು ಕೊಡಬಹುದು. ಆದ್ರೆ ಅದನ್ನು ಫಸ್ಟೇ ಹೇಳ್ಬೋದಿತ್ತಲ್ವೇ? ಅಷ್ಟು ಸುಲಭದಲ್ಲಿ ನಾನು ಫೇಲ್ ಆಗಲ್ರಿ. ಮನೇಲಿ ಯಜಮಾನರುಗಳು ಸೋತ್ ಹೋಗ್ಬಿಡ್ತಾರೆ ನಿಮ್ಮ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಕೊಯ್ರಿಗೆ. ನ್ಯಾಯಾಧೀಶರುಗಳು ಸೋಲಲ್ಲ. ಪಾಯಿಂಟ್ ಇಷ್ಟೇ ಹೋಗಿಲ್ರಿ. ನೀವು ಫ್ರಾಡ್ ಅಂತ ಹೇಳ್ಬೇಕಾದ್ರೆ ವೆದರ್ ದ ಫ್ರಾಡ್ ಹ್ಯಾಸ್ ಬಿನ್ ಪ್ಲೇಡ್ ಆರ್ ನಾಟ್ ಅನ್ಬೇಕಾದ್ರೆ won't it require recording of evidence? ಇಲ್ಲಿ ನಿಮ್ಗೆ ಅದು ಆಪರ್ಚುನಿಟಿ ಇರುತ್ತೆ. ಜನರಲಿ ಇನ್ನು ನಿಮ್ಮ ಕಂಟೆನ್ಷನ್ ಇದರಲ್ಲಿ ಫ್ರಾಡ್ ಅಥವಾ ಸಪ್ರೆಷನ್ ಆಫ್ ಫ್ಯಾಕ್ಟ್ ಅಥವಾ ಕೊಯರ್ಷನ್, ನಿಮ್ಮ ಪ್ರಕಾರ ಇದು ಇಟ್ ಇಸ್ ನಾಟ್ ಜಸ್ಟ್ ಎ ಫ್ರಾಡ್ ಆರ್ ಕೊಯರ್ಷನ್, ಇಟ್ ಈಸ್ ಎ ಕ್ರಿಮಿನಲ್ ಅಫೆನ್ಸ್, ಅಸಾಲ್ಟ್ ಅಂಡ್ ಥ್ರೆಟನಿಂಗ್ 506 IPC. ಸೊ ಅಷ್ಟೆಲ್ಲ ಬರ್ಬೇಕಾದ್ರೆ can under any stretch of imagination in a writ jurisdiction, it will go on recording the evidence, appreciation of evidence and everything. ನೀವು ಅದಿಲ್ಲದೆ ಬರೀ ಬೇಸ್ಡ್ ಅಪಾನ್ ಎ ಡಾಕ್ಯುಮೆಂಟ್ ಐ ಡೂ ಅಂತ ಹೇಳಿದ್ರೆ ಆರ್ ಯು ನಾಟ್ ಇನ್ವೈಟಿಂಗ್ ಸಮ್ ರಿಸ್ಕ್? ಏನೋ ಆಗಿ ನಾನು ನೋ ಫ್ರಾಡ್ ಈಸ್ ಎಸ್ಟಾಬ್ಲಿಷ್ಡ್ ಅಂತ ಹೇಳಿದೆ ಅಂತ ಆದ್ರೆ ನಿಮ್ಗೆ ಅಲ್ಲೂ ಇಲ್ಲ ಇಲ್ಲೂ ಇಲ್ಲ ಆಗುತ್ತೆ ಅಲ್ವೇ? Then proceed on the merit. I will hear you and pass the judgment on merit. Yes. Yes, proceed on the merit, please. You are challenging the compromise petition. You are the defendant number 2 in the trial court. Yeah, you allege that the fraud was laid upon you.
By the mother, brother, and all the sisters. I reside in Shumaga. And believing that all the things.
Where is that compromise? Annexure C.
Annexure C. Item number 2 of the annexure C, my lord, page number 17, that the property is vague, my lord.
Yes, please proceed.
In the concept of the proposal, my lords, they want to pay the amount, if they come out with the.
No, the matter I am now have taken it for final disposal. Kindly proceed on the argument on merit. Yes, proceed, please.
From this new judgment, my lord, June 30, 2021, Lord's Liberty Mediation.
Absolutely not. Absolutely not. Proceed with. I pass an order on merit. ನ್ಯಾಯಾಲಯದ ತಾಳ್ಮೆಗೆ ಒಂದು ಮಿತಿ ಇರ್ತದೆ. ನ್ಯಾಯಾಲಯನ ಎಷ್ಟರ ಮಟ್ಟಿಗೆ ನೀವು ಹಿಂಜಬಹುದೋ ಅದಕ್ಕೂ ಒಂದು ಮಿತಿ ಇರುತ್ತೆ. ಅದರ ಅಳತೆ ಮೀರಿದ ದುರುಪಯೋಗಕ್ಕೆ ನ್ಯಾಯಾಲಯ ಯಾವತ್ತೂ ಅವಕಾಶ ಕೊಡಲ್ಲ. ಈ ಪ್ರಕರಣದಲ್ಲೇ ಹಾಗೆ ಆಗ್ತಾ ಇದೆ. ನೀವು ಮೆರಿಟ್ ಇದೆ ಕನ್ವಿನ್ಸ್ ಮಾಡಿದ್ರೆ ಡೆಫಿನೆಟ್ಲಿ ಯು ಸಕ್ಸೀಡ್. ಬೆಸ್ಟ್ ಅಶ್ಯೂರ್ಡ್, ಬಿ ಬೆಸ್ಟ್ ಅಶ್ಯೂರ್ಡ್. ಇಫ್ ಯು ಕನ್ವಿನ್ಸ್ ಮೀ ದಟ್ ಸೇ you have got 3 judgments also, place those judgments before me. I will refer to all those judgments. I will also refer to that judgments of division bench which was brought to your notice, so that you cannot say that you are not aware of this judgment. And I will hear him also, and then I proceed in pronouncing my order. Yes, proceed with the merit, please. Yes.
Claim filed by the respondent hearing
Your defendant number. Yes.
Because only 2 scheduled properties are included in the claim, my lord. But after any entering into the order 23 compromise petition, all of a sudden they have included another 2 properties, my lord, which they, and number 7, my lord, citizen property, they declared themselves, and another paragraph number 3, my lords, they it kept for sale, my lords. From that amount, from that sale, even the sale agreement was not produced.
In a suit for partition,
Yes, my lord.
if the parties enter into a compromise, does it prevent them from including few more properties than or in addition to what was originally shown in the claim?
Not in the only one contention of my claim, my lord, that she was not aware of this. Only mentioned.
Fine, she was not aware of those things. How do you establish that she was not aware of those things? That means your alleged innocence or misrepresentation you are canvassing. It was misrepresented that the suit is for only with respect to 2 particular properties. However, in the compromise, few more properties were included.
One day, only one advocate present. And she put the signatures, and with all the belief she stays in Shumaga. And with all that innocency, she went, followed her brother and sisters, my lord. Even very hastily, without any application of mine, then the court has also passed the order of the decree. It was filed in the year 10/3/2017, my lord. The entire thing was closed, my lord. Same day, 23/3 was filed. The same day it was approved.
Yes. Some more properties which are not to your knowledge and not shown in the plaint were included. Yes. Point 1. Argument point number 2.
Self-acquired property. He says in paragraph number 4, ನಾಲ್ಕನೇ ಪ್ರತಿವಾದಿ ತನ್ನ ಸ್ವಂತ ವ್ಯಾಪಾರಗಳಿಂದ ಮಂಡ್ಯ ನಗರದ ಪೇಟೆ ಬೀದಿಯಲ್ಲಿ ಮುನ್ಸಿಪಲ್ ಖಾತಾಕ್ಕೆ that he himself has declared that he is how it has been brought, everything is the matter evidence. It's not taking the knowledge of the petition. How the entire thing was made and I was and when they entered the sub-registrar office after registering the same thing, my lords, she was, and her husband was beaten up by the brother, my lords, who was brought up by the same petitioner like her son, my lords. She beat her like a son, my lords. By invoking 226 and 227, my lord, since the advisory and judicial instruction, the court can know that ask the compromise or the violence and substantiate my argument and that my
Yes, please. Yes. Mark the relevant portion in the judgment. Yes.
Thank you. The judgment what made for the court, either it's a court or it's another. That's my my petition and around 23 would be that time. The councils is added on the members. There it lacks members. Even otherwise, the court would have taken, as per the order 32 rule A, my lords, have taken much care while doing the entire thing, my lords, before not using the documents. No documents were connected along with the order 23. All these things were not in
The court should have taken precaution under order 32. One minute. (32A) rule. Yes. Please.
of the order. The provisions of this order shall apply to suits or proceedings relating to matters concerning the family. In particular, and without prejudice to the generality of the provisions of subcode 1, the provisions of this order shall apply to the following proceedings concerning the family, namely a suit or proceeding for matrimonial life, including a suit for proceeding for declaration or validity of the marriage or as to the matrimonial status of a person. A suit for proceeding of any declaration as to the duties of any person. A suit for proceeding in relation to the guardianship of the family or the custody of a matter of the family under disability. A suit for proceeding for maintenance. A suit for proceeding as to the variety of defect of an adoption. A suit for proceeding instituted by a member of the family relating to wills, succession, and succession. definition of the family, everything is explained.
No, show me any rule there, what care the court was expected to take and what breach the court has committed. Rule 5.
Here in the family definition, it covers minors. What you would have honorable right of the Bible, you would have documents that have been produced along with the claim, documents produced along with the compromise. It ends up with the entire the concept of the compromise decree. There ends no appeal, my lord. The suit, end of the suit itself. It is good. When the fraud is made, the presentation has been made, then there is no common style between the parties. The entire proceeding should be shared. Or passed by the section MFC between the assignment. My petition to be allowed with them.
Yes, who appears for respondent? R1, R2, R4. Yes, proceed, please.
It is due to satisfaction.
1 minute. Yes, please.
It is due to the satisfaction of the court that a suit has been adjusted wholly or in part by any lawful agreement or compromise. Writing and signed by the parties, or where the defendant satisfies the plaintiff in respect of the whole or any part of the subject matter. Court shall order such agreement, compromise, or satisfaction recorded and decree in accordance therewith, so far as it relates to the parties to the suit, whether or not the subject matter of the agreement or compromise or satisfaction is the same as the subject matter of the suit. Now, one of the contention right is that there is a lesser number of properties, item properties, so in the claim and there, at the time of compromise, more properties are included. This provision will permit
Yes.
inclusion of any other property for which the parties can compromise themselves.
Yes.
And further, provided that where it is alleged by one party and denied by the other that an adjustment of satisfaction has been arrived, the court shall decide the question, but no adjournment shall be granted for the purpose of deciding the question, unless the court, for reasons to be recorded, thinks fit to grant such adjournment. So therefore, if any complaint is there
that the compromise is not lawful, or one of the parties is not satisfied with the compromise for some reason, or they found the legal defect, they should bring it to the notice of the court, then and then the court, the duty cast upon the court to hear that and take a decision on that. One more allegation is made that there is some coercion or intimidation induced the question of fact. But anyway, explanation says an agreement or compromise which is void or voidable under legal perspective should not be deemed to be the law. But before taking an exception to the decree passed by the court, the duty cast upon the petitioner to bring it to the notice, such a defect is brought to the notice of the court which has recorded the complaint. Unless and until that is done, no fault can be found with the order or the decree passed by the court. The other provision which is pointed out by my learned friend is 32A. Yes. Rule 5 of Article 32A. Article 32A. Rule 5. Duty to inquire into facts. In every suit or proceedings in which this order applies, it shall be the duty of the court to inquire so far as it reasonably can into the facts alleged by the plaintiff and into the facts alleged by the defendant. So therefore, duty is cast upon basically on the parties to bring it to the notice of the court. When such things happen, therefore, even if that has happened as alleged by my friend, anything has really happened. Even subsequently, they can bring it to the notice of the same court that this is what happened under the duress or under the intimidation I have signed that. Then the court can inquire into it and take a further decision on that. Insofar as Article 227 is considered the lordship is there. The jurisdiction is very, very limited. Under Article 227, duty supervisory jurisdiction and the court cannot go into the question, unlike in Article 26. And this one is already settled by the Supreme Court, but I am very sorry. Filing article, but then now, and my filing in fact, I have got that judgment also ready because in the all Supreme Court case. Now I am handicapped to show that. One judgment which my learned friend has pointed this is my judgment.
In her argument, no judgments are cited. On which point of your argument you are relying upon? A council relying upon certain judgment does not mean with a memo throw it in the court. No. They have to take up the judgment during the course of their argument, draw the attention of the court to that particular judgment and that particular portion of the judgment which they rely upon, explain to the court as to how that judgment is applicable in the matter before the court. Only then that can be taken that a particular counsel has relied upon or referred to a judgment. That is all. Yes. You are now relying upon two judgments. Yes. First judgment. Yes.
The justices, my lord, since having administrative and judicial, maybe rarely, my lords, in this case, it's a rare case that even the court has not made its mind, the plain scheduled properties are added, and another within a week, the same advocate has been handled the case, and within a week, the case has been ended up. So, in that instance, my lord, in order to meet the justice, where as an advisory, when a judicial power, the honorable court can invoke that and to allow the petition. And another regarding that there is been held that the compromise should not be recorded in a casual manner, but the court must apply judicial mind while examining the terms of the settlement. Is disposed of in terms of the agreement. This is the principle that the judicial mind has to be applied. Here, the trial court has simply mechanically, without not going through the entire records members.
Yes, please. Which para you rely upon? Yes, please.
The High Court in the process remained oblivious of the provisions of Article 23 ACPC. As also orders passed by the Supreme Court rejecting the plaintiff if the trial court had not only placed blame with the but also the decision of the court in Pushpa Devi's case, holding that a separate suit was not maintainable and that the only remedy available to the aggrieved party was to approach the court which had passed the complaint. The following passage from the decision of Pushpa Devi cases in this regard opposite. Therefore, the only remedy available to a party to a consent decree to avoid such consent decree is to approve the court which recorded the compromise and made a decree down of it and established that there was no compromise. In that event, the court which recorded the compromise will itself consider and decide the question as to whether there was a valid compromise or not. This is so because a consent decree is nothing but contract between the parties superimposed with the seal of the approval of the court. The validity of the consent decree depends wholly on the validity of the agreement or a compromise on which it is made. The second defendant who alleged his consent compromise decree was fully aware of this position as she filed an application for setting aside a consent decree on 21/8/2001 by alleging that there was no valid compromise in accordance with law. Significantly, none of the other defendants alleged the consent decree. For reasons best known to the second defendant, within a few days thereafter filed an appeal and chose not to pursue the application filed before the court, which passed the consent decree. Such an appeal by the second defendant was not maintainable and regard to the express bar contained under section 96(3) of the code. We may also refer to the decision of this court in Brahmari Chandu Devi, where this court has observed. As such, a party challenging the compromise can file a petition under Article 23 or an appeal under 96(1) of the code, in which he can now question the validity of the compromise in view of Article 43(1)(a) of the code. In the light of the code, no Article 43(1)(a) is amended, wherein there is a possibility an appeal can be filed. Yes. 43(1)(a), right to challenge non-appealable orders in appeal. The order is made under this code against a party and their party in an appeal against the decree. Such an order should not appeal against the decree passed in a suit after recording a compromise. An appeal against the decree passed in a suit after recording a compromise or refusing to record a compromise, it shall be open to the appellant to contest a decree on the ground that the compromise. There is a contention taken that the party was not aware. She said in Shimoga and she said the properties included, which the learned private code. Those contention. With regard to that, if such a thing is there, they can always find an appeal. Alternative. 5 Supreme Court cases also speak about maybe if a party is aggrieved by the compromise. Nine. The Mario case,
Yes.
it's true that a compromise forming the basis of the decree can only be questioned before the same court that recorded the compromise and a fresh suit for setting aside a compromise decree expressly barred under 3A. It is equally true that the expression not lawful used in our 23 also covers a decree based on a fraudulent compromise. Hence, a challenge to a compromise decree on the ground that it was obtained by fraudulent means would also fall under fraudulence of 23A. Therefore, my other suggestion is the writ is not necessary.
There are conflicts from both sides present. Are there arguments? For argument. There is counsel from both sides present. Before the learned counsel, proceed further in the matter for addressing their arguments. This court brought to the notice of the learned counsel about the judgment in Lakshmama and others versus Sri T.H. Ramegoda and others, reported in ILR 2015, Karnataka 4024, and invited their response to the same. However, the learned counsel for the petitioner opted to proceed further in the matter, addressing the argument on merit of the petition. Accordingly, that was proceeded. Heard arguments from both sides. Orders reserved.
Make one submission.
Yes. Yes, please.
Serial number 39.
Yes.
I appear for the petitioner.
Yes.
Request, my lords, interim order may kindly be extended.
JJ to file memo of appearance in this matter. The counsel for petitioner is appearing through video conference. The court term is over. The matter could not be taken up. This matter on 7 4/2023 on the top of the list. Interim order granted earlier is extended. Till then.
Grateful.
ಸ್ಕ್ವೇರ್ಗಳು ಯಾವುದೆಲ್ಲ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಇರ್ತಾರೆ ಆ ಎಲ್ಲಾ ಮ್ಯಾಟರ್ಗಳನ್ನು ಆಯಾ ಹೆಡ್ಡಿನಡಿ ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗು, ಬಿ ಗ್ರೂಪ್ ಹಿಯರಿಂಗು ಟಾಪ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಹಾಕ್ಸಿ ಅಂತ ಹೇಳಿ ನಾನು ಎಷ್ಟೋ ವರ್ಷಗಳಿಂದ ಹೇಳ್ತಾ ಬರ್ತಿದ್ದೇನೆ. ರೆಗ್ಯುಲರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಹೇಳ್ತಾನೆ ಇದ್ದಾರೆ. ಆದ್ರೆ ಈ ಸರ್ತಿ ಹಾಗೆ ಮಾಡಿಲ್ಲ. ಲರ್ನಿಂಗ್ ಕೌನ್ಸಿಲ್ ಅಮಿಕಸ್ ಕ್ಯೂರಿಗಳು ಇಬ್ರು ಬೆಳಗಿಂದ ವೇಟ್ ಮಾಡ್ತಿದ್ದಾರೆ. ಹೋಲ್ ಡೇ ಹೋಗ್ಸಕ್ಕೆ ಕೋರ್ಟಿಗೆ ಅಸಿಸ್ಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಅವ್ರು ಬರ್ತಾರೆ. ಹೋಲ್ ಡೇ ಅವ್ರನ್ನ ವೇಟ್ ಮಾಡಿಸದ ನಾವು. ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ, ರಿಜಿಸ್ಟ್ರಾರ್ ಜುಡಿಷಿಯಲ್ಗೆ ಹೇಳಿ, ಈಗ ನಾನು ಏನ್ ಹೇಳಿದ್ದೇನೆ ಅದನ್ನೇ ಹೇಳಿ. ಆ ಪೊಗಸಟ್ಟೆ ನಾವು ವರ್ಡನ್ನು ಸೇರಿಸಿ. ಯಾವಾಗ ಮಾಡ್ತೀರ್ರಿ ಇಬ್ರು? ಹಾ ಹಾ ತೆಗೀರಿ, ಅದರಲ್ಲಿ ಏನಿದೆ ಇಂಟ್ರಿ ಮಾಡೋಣ. The previous order not reached ಅನ್ನೋದನ್ನು ಹಾಕಿ learned counsel for the petitioner and learned amicus curiae correspondent are physically present. Since the court time is over, the matter could not be reached. Is this matter on 8/4? ಆಗ್ಬೋದಲ್ವೇ ರೆಡ್ಡಿ ಅವರೇ? The interim order granted earlier is extended till then. 29 ಕಳಿಸಿದ್ರಿ. ನಂಬರ್ 29 ಕೊಡ್ರಿ. ಇದನ್ನು ಟಾಪ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ನೀವು ಬರ್ಕೊಳ್ಬೇಕ್ರಿ. ಟಾಪ್ ಆಫ್ ದ ಲಿಸ್ಟ್. ಕಾಪೀಸ್ ಎಲ್ಲ ಬಂದಿದೆ ಅದರಲ್ಲಿ. ಫಾರ್ ಪಿಟಿಷನರ್ ಅವ್ರಿಗೆ ಸೇಲ್ಡೆಡ್ ಕಾಪಿ ಅಂತ ಕೊಡಿ. Learned counsel from both sides present. Learned amicus curiae submits that due to the non-availability of the copy of the alleged sale deed dated. ಏನಾದ್ರು ಇದೆಯಾ ಅದ್ರಲ್ಲಿ? ಒಂದೇ ಸೇಲ್ ಡೀಡ್ ಇದೆಯಾ ಅದರಲ್ಲಿ? ಈಗ ನಾನು ಬರೀ ಸೇಲ್ ಡೀಡ್ ಅಂದ್ರೆ ಗೊತ್ತಾಗುತ್ತೋ? ನಾ ಡೇಟ್ ಏನಾದ್ರು ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಕಾ? ಸೇಲ್ ಡೀಡ್ ಶಿ ಕುಡ್ ನಾಟ್ prepare fully. Learned counsel for the petitioner undertakes to furnish her a copy of the sale deed and other relevant documents pertaining to the matter within 3 days from today. ನಿಮ್ಮ ಹತ್ರ ಇದ್ರೆ ಅದ್ರದ್ದು ಕಾಪಿನೇ ಕೊಟ್ಬಿಡಿ. ಯಾವ್ದಾವ್ದು ಕೊಟ್ಟಿದ್ದೇವೆ ಅಂತ ನೀವು ನೆನ್ಪಿಟ್ಕೊಳ್ಳಿ, ಒಂದು ಚೀಟಿ ಬರ್ದು ಇಟ್ಕೊಳ್ಳಿ. ಒರಿಜಿನಲ್ ಕಾಪಿನ ಕೊಡಿ, ಇವ್ರಿಗೆ ಜೆರಾಕ್ಸ್ ಮಾಡಿಸ್ಕೊಂಡು ನಿಮಗೆ ಒರಿಜಿನಲ್ ವಾಪಸ್ ಮಾಡ್ತಾರೆ, ಅಥವಾ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಹತ್ರ ಕೊಟ್ಟಿರ್ತಾರೆ, ಇವ್ರ ಹತ್ರ ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಳ್ಬಹುದು. ನೀವು ಒರಿಜಿನಲ್ ಕೊಡಲ್ಲ, ಸೀನಿಯರ್ ಬೈತಾರೆ, ಕಾಪಿನೇ ಕೊಡ್ತೇನೆ ಅಂತ ಹೇಳಿದ್ರೆ ನಾಳೆ ಅದ್ರ ಕಾಪಿನೇ ತಗೊಂಡ್ಬಂದು ಕೋರ್ಟ್ ಆಫೀಸರ್ ಹತ್ರ ಕೊಟ್ಟು ಹೋಗಿ, ಕೇಸ್ ನಂಬರ್ ಏನು ಅಂತ ಪೆನ್ಸಿಲ್ ಮೇಲ್ ಬರ್ದಿರಿ, ಅಮಿಕಸ್ ಕ್ಯೂರಿ ಅಂತ ಅವ್ರ ಹೆಸರು, ಅವ್ರು ಕೋರ್ಟ್ ಆಫೀಸರ್ ಹತ್ರ ಇಸ್ಕೊಳ್ತಾರೆ ನಾಳೆ ನಾಡಿದ್ದು ಬಂದಾಗ. Either of these two things can be done. Entendri?
Copy of the sale deed and other relevant documents pertaining to the matter within 3 days from today.
List the matter on 11/4/2022 on the top of the list.